So I would like just to give a brief academic, boring stuff overview. And after that, I'll engage with you here on the slides. So please just bear with me about the overview, and I'll explain everything later with the slides. So usually when you hear the Islamic Sharia law, what comes up to mind? Yeah, cutting off the hand, or yeah. This is actually what comes up to the mind. So we call this in Arabic the hudud, and these are key theological elements that has been central to the recruitment efforts of both violent and non-violent political Islam movements. Hudud is a branch of classical jurisprudence, literally meaning limits, which broadly refers to the capital and corporal punishment and the penal code, in the penal code. Specifically, hudud refers to certain crimes and their punishments that include flogging, amputation of the hands or legs, stoning to death, crucifixion, and causing physical injury according to the law of talion or law of qisas or retaliation. Across the full spectrum of non-violent and violent Islamist groups, they have all used this concept as a yardstick to essentially claim that government and regimes in the Muslim majority countries that don't implement hudud are un-Islamic. And the duty of these overwhelming non-state actors is therefore to oust such governments and restore the application of these hudud. So my work here is to summarize the scriptural basis and the classical understanding of the hudud. Classical Islamic jurisprudence recognized that these hudud punishments were extremely severe and further reasoned that certain human rights are fundamental. The hudud were harsh precisely in order to defend those rights and underline their importance. This was one argument of the approach of Islamic ethics and law known as maqasid, or consideration of higher objectives of the Sharia rather than the letters of the law. Maqasid, the approach to Sharia, was developed by the greatest authorities of Islamic jurisprudence since the very beginning and has helped the Muslims to reinterpret the Sharia in an evolving and context-specific manner, dependent upon time, place, and the nature of each societal context. This is a process that continues today. But for some Islamist groups, the long-established flexibility of classical Islamic jurisprudence has been replaced by a new, inflexible, and excessively literalist approach to scripture, and therefore to the hudud punishment, insisting on their literal application whilst forgetting their ultimate meaning. In this research, we ended with a summary of contemporary juristic approaches to the hudud, all of them inspired by the spirit of the Maqasidi approach. We argue that the Quranic text related to the hudud punishment all emphasize the deterrence and the punishment in dealing with crimes, as well as encouraging repentance, forgiveness, rehabilitation, including the waiving of the punishment. This approach is similar to that established in modern criminal justice system, which include elements of deterrence, punishment, and rehabilitation. We also show that modern Muslim jurist endorses the replacement of medieval corporal and capital punishment with alternative punishments such as imprisonment, fines, restorative justice, and community-based approaches, a view that actually originated centuries ago. In essence, the medieval punishments such as amputation, flogging, and crucifixion are mentioned in the Quran, albeit with exhortation towards justice and forgiveness, because those were the standard punishment at the time of the Quranic revelation in the 7th century. Insisting on such medieval punishment today would be like insisting that Muslims wage war using horses, since horses are mentioned clearly in the Quran. So let me just, after giving you a brief overview about it, I think some people tend to underestimate this topic and believe that it's a sensational topic that we bring forward because nobody's doing it. And the surprising facts, it's not. It's actually, a lot of countries are actually still implementing the hudud in the modern time. Also parts of Indonesia and Malaysia, all of that is still implementing the hudud. in the literal application, so still relevant, still happening. It is not something obsolete. It is really relevant to our modern time. So let's try to understand, grasp what the classical Islamic theory says about that. And this classical theory is mentioned, formulated by the Muslim jurist in the medieval time. So this is the classical period theory. So we have something called fixed punishments, and they call it hudud because it is mentioned clearly in the text of the Quran or the Hadith. Again, this include public punishment, which include these 1, 2, 3, 4, 5, 6 punishment. By the way, the number of the hudud varies from one school to another, but they agree on that. So these are the public punishment. In the classical theories, we have something else called private issue, private laws, which the law of retaliation. Actually, law of retaliation. If someone killed someone, the classical theory is not interested. The state doesn't interfere in that. It is the family who persecutes the offender, but not the state per se. And usually, there are, if it is physical murder or physical injury, it ends up either in retaliation or blood money or complete forgiveness, and the story is finished. These are fixed theory or fixed kind of definition of crime and punishment. But equally, the Sharia, even in the medievalist time, has recognized the rights of the human being to face the emerging nature of crimes. And this is called the punishment of ta'zir, and I call it dynamic. So any other punishment which is not mentioned clearly in the text, is the Sharia has granted laws to the judges, to the rulers, to the people of authority to legislate for themselves to face the emerging nature of crimes. So this is the classical theory. And nowadays, if you would like to implement this in modern society, you will have lots of challenges and lots of problems. First of all, the Universal Declaration of Human Rights. Any kind of punishment which degrading or physical injuries is actually against human rights. International Covenant on Civil and Political Rights, Convention Against Torture, and other human and degrading treatment or punishment. Also, for citizenship, equality before the law or the rule of the law itself. Under the classical theory, if a Muslim killed a Christian, he is not going to be killed in return because it's a belief that the Muslim blood is superior to a Christian. So he will not be killed. The blood money of women is half of men because the classical perception that women earn less and they gauge it against the contribution towards the household. Again, the rule of the law. Certain types or most of these laws, most of these punishments, whether it is adultery, false accusation of adultery, theft, highway robbery, it's mostly applied to non-Muslim subjects. So even a Christian who doesn't believe in that, it's actually implemented against his own will. So you have a huge, serious challenge to citizenship, to human rights matter. So this is how it is. What is the possible solution? What should we do? Some people, like others, they say we have nothing to do with the context or with the evolving matters. Forget about it. The text is saying this, and we have to move forward. Others ignore completely the changes, and others recognize the changes and readdress the huge challenge facing Muslims in this specific context, and try to reread or re-understand these kind of punishments in the modern periods to harmonize the relationship between your faith, which is very important, and equally between the international agreements and modern context. So there are various attempts who try to negotiate this. Even if we trace it back to medieval times, there are hundreds of examples who recognize, first of all, that these punishments are severe and it is not regularly applied, but they say it can be applied. No one says it is impossible to be applied. They say it can be applied, but in certain cases. So medieval scholars have put very strict measures and requirements for this punishment to take place, like various numbers of witnesses, which is impossible to achieve, very strict rules. I can't just go in details about that, but I leave it when you read this as a paper. Also, there are inconsistent contextualization of the hudud. Various individuals and organizations throughout the world try to negotiate this. So they say, we suspended the hudud through achieving economic welfare and material progress, or selectively reforming one penalty only. So in terms of cutting off the hand, they say, we just make a economic welfare and the people will stop stealing, and therefore this punishment will not be applicable. But they forget other punishments like crucifixion or stoning, or other initiatives have reformed one particular punishments like stoning to death, and say it's inconsistent with the spirit of the Quran because it is based mainly on the hadith. We have some kind of consistent reforms, like, and it is based mainly legal and rational and maqasidi and humanistic consideration. We have people who have done that, like the Grand Mufti of Egypt. He clearly stated that hudud can be replaced by modern legal punishment based on these. These schools also recognize that hudud is a historical penal code and can't be implemented because of modern legal complication. And when we say moral and legal rational elements, they say because of the conflict with the religious matter, the moral matter, which is religious matter, with a legal matter. So complications of, or the intersection between legal matters and moral or spiritual matters. For example, Sharia recognizes that the thief, if he reversed his confession that he has committed the crime, it will drop the penalty. He's just forgiven straight away. So this will leave a vacuum in the legal system. You will not, again, someone is stealing and you are unable to persecute him because of these elements. So there is a religious element and legal element. And this makes it completely hard to canonize as a recognized law because of the complicated nature of this. We have Muslim intellectuals and philosophers. They shifted away. They didn't deny that these important things that mentioned in the Quran, but they read the spirit of these punishments. These punishments meant to punish or to deter people, but you can use other kind of punishment rather than the historical punishment. And they also try to rationalize why, for example, the Prophet in his time cut off the hands of the people, because there were nomadic societies, no prisons, and the people will the people will also recognize one another. So when you cut off the hand of someone, it deters the rest of the society. It has something to do with the social order of the society, which will not work in today's society at all. These including great philosophers like Hassan Hanafi, for example, or Muhammad Abid al-Jabri in Morocco, or Fazl al-Rahman, or other philosophers which we recognize. So my proposed actually theory is that to be fair to our tradition and at the same time fair to our modern society, I believe that this fixed part of the Sharia, all of it private or public, have to run under the classical concept of ta'zir, the right of the people to legislate for themselves. Even in the past, that's what's the case, that the people, the ruler, can make new law to face the emerging crimes. I believe that the classical theory, all of it, is modern types of ta'zir, not the classical concept of ta'zir, but only the principle of ta'zir, that the people have the right to legislate for themselves. And for me, would be the parliament, the law that is produced by the parliament to face emerging crimes and legislate for those crimes is actually in the spirit and in harmony with the tradition. In this way, I guess that aims to harmonize the letters or the spirit of the law with the modern state demands, and this is all.